Senator from Massachusetts, Mr. Kennedy, recognized.
Mr. President, I see the senator from Mississippi and Arkansas here. I would hope that we could get about to the debate now on the formulas. It's 4 o'clock. I appreciate the desire of our colleagues to address the Senate on different matters. This is a very important bill, and I'm glad and will stay here during the course of the evening, but until we come to grips with this. But I hope we can get into the we have asked the members to come down last evening. We've asked them this morning. We've asked them earlier in the afternoon. If we want to get into a situation, I hope that we can deal with the formula, which is a very legitimate issue in question, and get to move forward with the debate on that item. It is important, and I would just hope that we could. I know there are members that do have amendments. We're going to ask them to come on down here. We're going to move on through. It's 4 o'clock. Unless they're going to come down, we're going to ask for the third reading on this measure. We tried to accommodate. The majority leader has. And if we're not going to find members here, I'm going to go ask the majority leader if we can't move ahead. We've tried to accommodate. We've remained here on the floor. And we'd like to address what are the central issues on an item which is of enormous importance to the young people in this.
Would the senator from Massachusetts yield?
Sure.
Senator from Washington.
I believe that he or his representatives and I and the senator from Vermont have now agreed on a procedure to deal with what is the the order, the amendment which I introduced this morning. And I think at least tentatively from the perspective of the senator from Vermont and myself, if we could quite soon agree to a time arrangement under which we voted successively on the two amendments at, say, 6 o'clock, I think that's time to get everyone here who wants to speak on those amendments. And so if he can clear that on his side, I think I can clear that from the perspective of my own amendment. We could be on something of substance. We could get it done. We could have those votes and go on to something else. And you know, I'm working on a minor amendment to the Senator from Illinois' amendment. As soon as that's worked out, we could take that up, I suppose, and pass it in about 30 seconds.
Well, let me say the senator from Washington has been extremely patient and willing to work with the members here. And we will inquire from the interested senators on this issue. I would hope that we could do that prior to the time of the hour, but we'll certainly talk with you and do it in a way in which you and Senator Harkin and others would want to do it. But
in any event, we're ready.
If we are able to move that in a more timely way to do so, but we'll certainly work out that time with
we're ready to go whenever Senator
Harkin now.
Yes.
To go, and as I understand from staff, the other interested parties are prepared to go as well.
Who seeks recognition?
Mr. President.
Senator from Arkansas, Mr. Bumpers, is recognized. Without objection, the amendment number...
Mr. President, what is the pending business? On behalf of myself...
If the senator would withhold for a moment, the pending business is amendment number 2423.
Mr. President, I ask unanimous consent the pending amendment be temporarily set aside so that I may offer an amendment.
Reserving the right to object.
Senator from Vermont.
As to the pending amendment, I believe, is the Gordon amendment?
It's the Simon amendment.
The Simon amendment. Okay.
That's correct.
Well, may I inquire from the reserving my right to object, require from the gentleman from Arkansas as to what the length of time his amendment will take, and whether this is something that can be accepted or whether it's going to require considerable debate?
Senator, I can't be very definite about this. It's a very important amendment, and my guess is it's going to take a while.
It's my understanding it's a formula amendment?
Yes, it is. It's a Chapter 1 formula change.
Well, I know
Mr. President, I object.
What?
An objection is heard. Does the senator yield the floor? Senator from Massachusetts, Mr. Kennedy,
I would hope that we might accommodate. We've been trying to get this formula amendment issue is going to have to be debated. It reaches sort of the heart of the soul. We don't want to disadvantage any members on this. but we are in the process of notifying, getting other senators that we're interested in other issues, and I would hope that we could move ahead on it, and if we're able to get, as soon as we're able to get others, we will try and at least see if we can't resolve those items which are pending.
But with the Senator yield.
Senator from Vermont.
Still reserving the right to object. I do so because we now have Senator Harkin coming on the Gorton Amendment, and the Gorton Amendment has been set aside. The senator from Washington is ready to go. We're ready to agree to a unanimous consent on this and get it out of the way so we can clear it, and then spend the rest of the time probably on the formula amendments. So I would urge us that we allow us to get back to the Gorton Amendment and resolve that, and then proceed on to all the formula. We got two formula advocates here, and it would seem to me to be more logical to bring it in that kind of order.
Well, Mr. President, then I appreciate the senator. I see the senator from Arkansas and Mississippi on the floor on this, and we have been trying to urge them to come over here for some period of time, and now they, as they are experienced legislators and familiar with the way this process works, we're going to now then move ahead and vote on the Grassley, the Gorton, the Gorton amendment and the Harkin amendment, as I understand it.
With the Senator yield. We're certainly prepared to debate it. We are certainly prepared to enter into a time agreement on it. And in order not to waste any time, I'm prepared, or I'd really prefer that the manager simply call for the regular order, bring up our amendment. The agreement is this, that the Gorton Amendment will be debated and dealt with. At the same time, the senator from Vermont is going to explain his alternative amendment to it. We'll try to enter into one-time agreement on both of them and vote on them successively.
If I can
hopefully in a
suggest
relatively short
a way
period
of
of time.
proceeding, Mr. President,
Senator's recognized.
and that is that the senator from Arkansas withhold offering the amendment. We begin to start the debate on it. That preserves the senator from Washington's position. And we're all the interested parties here. We'll try to resolve this, and I think that would be the best utilization of the Senate's time. Otherwise, we're going to be into a period of a quorum call. If we could, the senator could. I think there's really not much of a mystery about the basic concept. I know the senator will want to address the substance of it, but if we could proceed in that way, I think it would save us a good deal of time this evening. But I'm glad to accommodate the...
With the senator here for a question.
Sure.
Senator from
Is the
Arkansas.
senator from Oregon prepared to offer and debate his amendment?
Are you speaking about the senator from Washington?
I'm sorry, Washington.
And what was the question?
The question was, is the senator from Washington prepared to offer his amendment and debate it?
The senator from Washington's amendment is the regular order.
Is that
and the senator from Washington is prepared to make a brief additional statement to the one that he made this morning, to let the senator from Vermont speak on the other side. We have notified the other proponents, and I understand Senator from Idaho, Mr. Harkin, who is on the same side as the senator from Vermont on this, is on his way to the floor. I just as soon start on the Gorton Amendment and the companion Jeffords Amendment and finish it as quickly as we can. Well, and the answer is I am prepared to start on it now.
Mr. President, let me say to the senator from Massachusetts, I want to be helpful, and I know how frustrating it can be to sit where he's sitting and wait for action. Now he's perhaps got more action on his hand than he wants, but I'm reluctant to sever our amendment by beginning the debate and then going to these others and coming back to it. I think the senator can understand that.
Okay. Well, I would suggest then we start the debate on and conclude the debate on the senator from Washington, and I would ask that the interested senators on this issue come to the floor, because when the senator from Washington concludes, we're going to move ahead on this in terms of having the votes on it, so that those members who are interested, we're urging them to come to the floor. We've tried to accommodate on this issue since early this morning. I think we've got, as I understand, a way of proceeding, and I would hope that we would accommodate, listen to the senator from Washington, those that have a differing view, which I personally do, but I know there are other members, and then I hope that we're going to resolve this issue so that we can move ahead.
Mr. President,
Arkansas.
Would the senator be willing to entertain a unanimous consent agreement so we don't have a hiatus and we can move expeditiously, as he has suggested, a unanimous consent agreement that the regular order be following disposition of the Gorton Amendment, the Bumpers-Cochran Amendment? I promise you I'll be here ready.
Let me...
Senator from Vermont.
I would, well, I guess to get this on process here, I would ask the unanimous consent that we proceed immediately to the Gorton Amendment, and that after some time to be agreed upon, we vote on the Gorton Amendment. Immediately after the Gorton Amendment, an amendment to be offered by myself, Senator Jeffords, would be in order for a debate time to be limited and to be voted on, notwithstanding whatever the result is on the Gorton Amendment.
Will the senator yield before I lodge an objection to that request?
Senator from Illinois, Ms.
The amendment on equity in athletics is still pending. We've agreed on a modification. If we can have that adopted by voice vote and then go to the Gorton Amendment as stated in your unanimous consent request, I would be prepared to withdraw my objection.
Well, I have no objection to that being as part of my unanimous consent. Immediately prior to going to the Gorton Amendment, we take care of the amendment from the gentlewoman from Illinois.
Madam President, we're going to go back. We're trying to accommodate the members here. And now I'm going to ask for the regular order, and we're going to follow the rules of the Senate. We have attempted to accommodate different people on different times, on different ways, and the members are entitled to know that we're going to proceed by the Senate rules. So I'm very grateful to all of those who tried to be helpful, but we have now different matters that are before the Senate. We have the Senate rules, and we're going to follow those particular rules and dispose of those amendments in an orderly way, and we'll just do the best that we can and stay here as long as we can. I'm grateful. This in no way reflects in terms of others who have tried to accommodate, but we just have too many members who have interest, and in order to preserve all of their rights, we're going to follow the Senate rules, and I would ask now that we have ask the Chair, what is the regular order?
Regular order is the Gorton Amendment.
Regular order is the Gorton Amendment.
The senator is correct.
Then we will proceed with
That is now the question before the body.
Mr. President,
Senator from Washington.
The senator from Illinois has been most generous to me, and as I understand it, all she needs to do is modify her amendment. I don't believe there's any more debate, and we can pass it in 30 seconds. I don't want to keep here for 2 hours for that. I ask unanimous consent that we allow the senator from Illinois to modify her amendment and bring it to a voice vote.
Is there an objection?
We're reserving the right.
Senator from Massachusetts.
I was distracted for a moment. Would the senator restate his consent?
I ask unanimous consent that we allow the senator from Illinois to modify her amendment and bring it to a voice vote on the understanding that it requires no further debate and it will be agreed to, and we can have it off our agenda in 30 seconds.
I thank the senator from Washington and the senator from Massachusetts. I send a modification to the desk, and I ask for the...
Without objection, the amendment is so modified. The question is on the amendment as modified. Those in favor will signify by saying aye. Those opposed? The ayes appear to have it. The ayes have it, and the amendment is modified.
Move to reconsider.
Without objection, so ordered. The senator from Washington, Mr. Gordon, is recognized.
Mr. President, at 10:30, roughly 10:30 this morning, I laid down the Gorton-Lieberman amendment on school violence. It was debated briefly at that time, and it is obviously controversial. And 4 members, I understand that the procedure that we will attempt to follow in this case for the convenience of all members is that we will now discuss that amendment, and Senator Jeffords and others will discuss an alternative amendment on the same subject. We hope that a unanimous consent agreement will be reached under which there may very well be a time agreement, but that in any event the two amendments will be voted on one right after another. Since they do relate to one another, there doesn't need to be additional time after the vote on my amendment before the vote on the Jeffords amendment. That obviously hasn't been completely worked out yet, but that is the goal of, I believe, the proponents of both amendments. Now, Mr. President, my amendment, simply to summarize briefly what I said this morning, is an amendment to restore a significant measure of control over seriously violent conduct in schools to local school district authorities. Specifically, the amendment covers the weapons violations in schools and life-threatening acts and activities in schools on the part of students. With those life-threatening activities narrowly defined as it is defined in the Sentencing Commission guidelines. These, of course, are forms of authority which the public schools of the United States exercised from time immemorial until the United States Congress began to involve itself in individual school discipline. There are two parts to the amendment. One is a general statement of the delegation of authority over offenses of this sort to the schools. The second is an amendment to the Individuals with Disabilities Education Act of 1975, which amends that act so that the same rules with some restrictions apply to those who are disabled, pursuant to which they can be removed from the school situation for up to 90 days as long as they are provided with an alternative opportunity for education by a particular school district. Now, under IDEA,
A moment till we have order in the Senate. Senator may proceed.
Now, under IDEA, a student, no matter how violent, no matter how life-threatening his or her activities, no matter how offensive a weapons violation, cannot be removed from class, from school, for more than 10 days without the permission of the offender's parent or a court order under federal law, which generally speaking must come from a federal court. This means in practical terms for our school authorities that their disciplinary authority is almost negligible in this case. We have a myriad of cases in which dangerous students are consistently and constantly returned to school after very, very short suspensions. Many instances under which the parents of the children against whom the offense is committed feel that they have to take their children out of school because of the inability of schools to provide for this type of discipline. Some instances, at least, of teachers resigning their teaching positions because they can no longer control their classrooms. This senator, speaking on behalf of teachers and school administrators and parents and school directors, as a result of what he learned in January, very surprisingly, at an education summit, would very bluntly prefer to grant much more authority to local school districts. General disruption in the classroom ought to be the subject of discipline by local school authorities. It should not be interfered with by laws passed by the Congress of the United States. But in order to narrow the focus on only the most dangerous activities, the amendment that I have introduced together with Senator Lieberman and others only applies to weapons violations and a narrowly defined life-threatening kinds of activities on the part of these students. The senator recognizes, for some reason or other, that this is extraordinarily controversial, but for the life of him cannot understand why it should be so controversial. Two reasons occur to this senator only. One is that this Congress simply doesn't trust teachers, school administrators, members of school boards to make even these most fundamental decisions about the way in which their own schools are operated. And secondly, the answer is that next year the Individuals with Disabilities Education Act is up for reauthorization, and we ought to defer a discussion of this subject until that time. In response to the latter objection, this senator has sunsetted the provision in his amendment to expire automatically when IDEA is in fact reauthorized. Now, we know that the mere fact that it's up for reauthorization next year doesn't mean that it will be reauthorized. It could be another year or 2 or 3 years. We will discuss this subject then. I suspect this senator will want a much broader delegation of authority to school districts then, but in any event, this amendment will be subsumed in whatever is passed in such a reauthorization. Until then, however, I don't believe that just because that this law is holy writ, that with all of the problems our schools face, that they should have to wait another year or 2 years or 3 years for a degree of authority which almost every rational person thinks they ought to have at the present time. Now, the choice, single or double, which the Senate will make as a result of the informal agreement reached with the managers of the bill, is that Senator Jeffords will put forth an amendment which differs in 2 respects from my own. First, it will excise from my amendment any reference to life-threatening activities. In other words, the Jeffords amendment will not allow school districts to avoid all of the detailed provisions of IDEA in connection with life-threatening activities on the part of students. I think that explanation of the difference should show members how they ought to vote. Why in the world we shouldn't allow school district authorities greater than their very narrow authority right now when life-threatening activities take place in their classrooms, I can't figure out. And the other difference is that our amendment has sections applying to all students, delegating an even broader authority for those students who are not disabled. That section, as I understand it, though I haven't seen its final form yet, is not included in the Jeffords amendment. So members will make a modest step forward if they were to pass only the Jeffords amendment. At least it does something with respect to weapons violations. It does nothing with respect to life-threatening situations in our schools. But we will get to vote on both of these amendments. It is, I suppose, consistent to vote for both of them, or to vote for neither, or to vote for one and not to vote for the other. But the fundamental difference between the two is whether or not we think there should be some change in the bureaucratic, court-ridden system now of disciplining students who engage in life-threatening actions during the course of their time in schools. And, Mr. President, this whole thing is getting more and more bizarre as we go on. You know, we've heard in another connection, and we now have at least a report of one court case in which the disability claimed to protect the student is the fact that the student brought the gun to school. The student brings the gun to school. The school attempts to discipline him. He's not a disabled student. And he claims that the mental condition that caused him to bring the gun to school is itself a disability, so he can't be disciplined, or can't be disciplined beyond the very, very narrow parameters of the present law. This is just too much to take, Mr. President. It's time that we allow school district authorities a greater degree of discretion with respect to students who bring weapons to school or engage in life-threatening behavior with respect to other students or their teachers.
Senator from Idaho, Mr. Craig is recognized.
Mr. President, I stand in support of the Gorton Amendment this afternoon. And earlier, before we went into recess, I also spoke in favor of the Feinstein Amendment, the Feinstein-Dorgan Amendment, that related to guns coming to the schools of America. And the willingness on the part of this Senate to say in a very straightforward way that that is just not acceptable. The Gorton Amendment says that it is not acceptable that we don't recognize violence in the classroom and that we don't give local authorities, school authorities, the opportunity at appropriate discipline in the discouragement of that kind of activity. So for a few moments this afternoon, I would like to interrelate a concern that I have that I think is spoken to in the Gorton Amendment. It's also addressed in the Feinstein Amendment. And that is that it is clearly time for our country and this Senate to speak directly to the responsibility of the individual and the need to allow local authorities to be able to discipline and to respond accordingly to the act of the individual instead of to this rather general approach we've had over the years that somehow individuals were products of society and that we had to be careful in how we handled them because they were simply disadvantaged in the nature in which they had been socially adjusted. And if they were misadjusted, somehow that was not the fault of the individual, it was the fault of society, and we must accordingly respond. You know, Mr. President, that's kind of part of the debate that is involved here this afternoon and why there are some senators that would like to modify the Gorton Amendment. The Republican leader was on the floor just a few moments ago speaking to his frustration over a crime conference that struck from a crime bill some very strong efforts to react to and to control individuals in this society who've decided to be deviant from the laws and the norms of our society and somehow either go undisciplined or in some way almost rewarded for their deviant acts. That's probably why we're debating education today, and in the mix of that educational debate, we're talking about guns. It is almost unique that we would be doing so. But the reason we are is because over 250,000 guns a day come to our public schools. And our local school officials' hands are nearly tied in their inability to act responsibly, directly, and quickly to that kind of an issue. Something's wrong. The senator from Washington is attempting to respond to it. Senator from California is attempting to respond to it. Senator from the Dakotas is attempting to respond to it. So for a few moments this afternoon, I'd like to react to it with a statement that I thought about for some time in relation to an action that is underway by this administration as it relates to the control of criminal violence in our country. And while it doesn't seem to fit in the educational context, I think it does fit, because it's most appropriate that we discuss it here this afternoon. I think some of you may remember the summary that was featured in the article in U.S. News and World Report in April. And it also mentioned certainly a colleague of ours from the West, Congresswoman Barbara Vukanovich of Nevada, on the House, on the House floor during a debate on the gun ban. It's the product of an interagency working group on violence appointed by this administration, a group composed of representatives from the Departments of Agriculture and Education and Health and Human Services, Housing and Urban Development, Justice, Labor, as well as the Domestic Policy Council and the Office on National Drug Policy. Why should anyone take notice of this kind of activity? And why should I be discussing it this afternoon in context to this particular bill? Here's why. Because I think that there are some important statements here that are very frustrating to me, but are reflective of why we're here debating the issue as we debate it today.
Yield for unanimous consent request.
Be more than happy to
Senator
yield.
from Massachusetts.
Mr. President, I ask unanimous consent that Senator Gorton's amendment be laid aside, that Senator Jeffords then be recognized to offer a first-degree amendment on the same subject as Senator Gorton's amendment, number 2418, that there be 45 minutes under the control of Senator Jeffords and 30 minutes under the control of Senator Gorton or his designee, that upon the use or yielding back of the time, the Senate proceed to a vote on Senator Gorton's amendment to be followed by a vote on Senator Jeffords' amendment, and that the votes take place without any intervening action or debate, with no amendments in order to either amendment.
Is there an objection?
You want to ask for the yeas and nays?
So ordered.
Are not the yeas and nays already?
The yeas and nays have been
vote?
ordered on the Gorton
Jeffords
amendment.
Reserving the right to object and a query. Senator Craig is now speaking on a somewhat different subject. Is this, you see, to begin upon the completion of Senator Craig's remarks?
Well, I'd ask that it be in order, that it be in order at the conclusion of Senator Craig's
Thank you.
remarks.
Is there an objection? Hearing none. The chair would inform the senator that
Well, when the
it's not in
senator,
order
we ask
to
consent, but
request
when
the
the
yeas
senator,
and nays in an amendment that's not before the body.
when the senator does offer his remark, that it be in order to ask for the yeas and nays.
It would be in order at that point.
Well, could we ask consent that it be in order this time?
Yes.
Is there an objection?
I have not offered the amendment at this time. I would ask unanimous consent that I be allowed to offer the Jeffords amendment at this point.
Yes, for yeas and nays.
Okay.
Yeas and nays.
Is there an objection to the previous unanimous consent request dealing with a time limit?
Then I would now the amendment.
Without objection, that order will be passed.
Thank you.
Mr. President,
Senator would hold a moment about this amendment he just did.
Okay.
I would also ask unanimous consent that this interlude does not appear as a break in my comments as they're put upon the record.
Without objection, so ordered.
Mr. President, I was discussing a report on violence that was produced by a group of individuals inside the Clinton administration. And I do believe it does fit the debate and the discussion that we're involved in today. Now, the question is, why should we take notice of this particular report, and why does it fit in the context of our debate today? For one thing, some of the suggestions in the summary are already implemented and are working their way through the process of the executive branch of Congress. Others may still be under review, but more importantly, the suggestions in the report that relate to violence in America tell us a lot about the mindset of this administration and the President's closest advisors, and why somehow this Senate doesn't want to give to local school authorities direct ability to discipline deviants or students who would choose to act against the well-being of fellow students. Now, I'm particularly interested in a section of the summary of that report that deals with firearm violence. Before turning to what this section says, let me tell you about what it doesn't say. What is completely missing from this section is any acknowledgement of firearm benefits. And now, I'm not talking about sporting and hunting. Somehow today, as people discuss firearms in America, they only want to say that under the Second Amendment, it's sporting and hunting that's appropriate. Those may be benefits enjoyed by millions of Americans, but this report is supposed to be about violence and not recreation. What I'm talking about is the fact that guns save lives and prevent injuries, crime and violence in our country every day. This report completely ignores the fact that guns are used for self-defense at least as often, and statistics will suggest substantially more than they are used in violent acts with criminal purpose in mind. Our founding fathers knew that firearms secured liberty. Millions of Americans since their time have understood that concept. Today, perhaps half of America's households own guns. We take our gun ownership for granted, just as we take for granted that our government would never force us to give up means of self-defense. Now comes this report. Not only does it list a variety of schemes for regulating firearms, but it even gives strategies for reshaping the way people think about firearms in America. Those strategies including building a scientific basis for justifying gun control and exploiting human psychology to build antagonism toward guns. Now, while we're dealing with education, there's nothing wrong with what this bill is attempting to do. It sets simply parameters of ownership, in this case, in light of juveniles and in all acts of the juveniles of America. Over time, we said certain things were appropriate and certain things were not appropriate. But what is interesting is that this administration is saying, and this report clearly says, that with the rest of America, we need to talk about a paradigm shift to move the debate on guns away from philosophy and into this discussion of accident statistics. In other words, Mr. President, this report urges the administration to forget that liberty is at stake and that there's another side to the gun debate and to this debate except violence. This report does not suggest any research into the defense or the defensive use of firearms. It does not suggest methods for promoting gun ownership for purposes of marksmanship and responsible actions. Instead, it portrays the gun as a menace to society, and in the section entitled Description of the Problem, it refers to a flood of guns, an epidemic of gun violence, and it suggests that the federal government ought to take such appropriate action to curb firearms injuries that it took with highway safety. All of a sudden it becomes this manageable thing out there that if you simply write the right federal laws, it's as easy to manage as highway safety. Aside from the constitutional problems that this argument obviously has, and they've obviously ignored it, there are problems I just mentioned. Unlike motor vehicles, firearms actually play a role in preventing injuries and death if properly used right. There's also the problem that virtually all motor vehicle injuries are the result of an accident, while only a tiny fraction of gun injuries are accidental. But let me get into the specifics of this report. The report's recommendations include excise taxes on guns and ammunition. That's already been debated on the floor. It's been talked about at least. Licensing, registration, bans on manufacturing, and reducing the number of licensed firearm dealers. Let me read a few excerpts from this report. By the way, this was a report that was kept under lock and key. Press couldn't get their hands on it until just recently. Other individuals who tried to acquire it were told that it wasn't available. We finally demanded its presence in our office, and it was brought to us. Let me quote from the report. To complement the above measures, effective firearms control should be considered limiting production of certain types of firearms and ammunition. Consideration should be given to placing higher taxes on handguns. Increased excise taxes on handguns and particularly dangerous ammunition would help offset the cost of providing medical care to gunshot victims. Well, we've already heard that debated. Now it's in a report. It's being handed to the President. If additional taxes are going to be imposed, consideration should be given to setting them at a cost per gun or bullet rather than the percentage of manufacturers' prices. Perhaps cheap guns and expensive guns can do equal damage. That's what the report says. New requirements that firearms purchases be licensed and or mandated that the owners be registered when they acquire the firearm. But that's not all. The working group has a lot more in their recommendations. In addition to, or as an alternative to, a licensing scheme where firearm purchasers may have to pass a gun safety test and a background check, and now I'm quoting again from the report. To pass a background check to receive the permit to buy a firearm or ammunition, the federal government should consider creating a class of restrictive weapons. This list would include all handguns and semi-automatic long guns that are not otherwise outlawed and could be purchased or carried only by persons holding valid registration certificates. Be happy to yield.
We, of course, have accepted the Dorgan amendment, and we were trying to at least indicate to the members about how we might proceed. We've talked, the Senator Feinstein, Senator Dorgan, I know the Senator from Idaho has talked on this amendment previously. I wonder how much, just in terms, we have a consent agreement now in this Senator Gordon's amendment, Senator Harkin. I'm just trying to accommodate other members to try and find out how we're going to proceed. Senator Bumper, Senator Corcoran were here, so I'd like to try and accommodate the members. Everybody will be talking in a little while, in a couple of hours, wondering about what the program is. And we have tried during the course of the day to be able to let people know. Could you give us, since we have already accepted the amendment, I was inquiring whether what the wishes were of the senator.
I appreciate the chairman's inquiry. I would take no more than, in fact, I would ask unanimous consent that I be allowed to proceed for no more than 5 minutes.
Thank you.
Hearing none, so ordered. Senator is recognized for 5 minutes.
Mr. President, the report goes on to talk about a clear scheme of the registration and the ownership of firearms and a control of them. It goes on, and I quote, the federal government would regulate secondary transfer of all firearms. The transfer of firearms, the unlicensed person would be required only with the transferee either to go to the premises of the licensed dealer and to submit documents of transfer, and this is in a private interchange of guns ownership in our country. The group suggests also reducing the number of licensed dealers and charging a $600 a year fee. I thought we'd already addressed that problem in the crime bill. It goes on to say, furthermore, we would consider adopting on a national basis the Virginia law prohibiting licensed dealers from selling more than one gun per month and so on. These schemes are offered in the name of making it harder for the wrong people to get guns. But, Mr. President, there is nothing in any of these schemes that limit their effect to the wrong person. On the contrary, each and every one of these ideas would restrict the ability of the right people or the law-abiding people to obtain firearms for legitimate purposes, including the prevention of crime, injury, and death. In this country, we don't restrict the freedoms of everybody in order to prevent the crimes of the few. For instance, we don't require reporters to submit their writings to a government board for approval before publication to prevent false reporting. That's called First Amendment rights. We respect due process for everyone, even though some criminals may benefit from it. We don't require people to get government clearance before they join associations, even though a certain association might be formed for purposes of criminal activity. The report doesn't stop here. It goes on to say some other very significant things as it relates to the idea of establishing a scheme under scientific bases to begin to argue against guns in our society. For example, it suggests undertaking research through the Center for Disease Control about patterns of acquisition, ownership, and the use of firearms that cause certain kinds of injuries, and it asked to establish a national firearm injury reporting system, and so on and so forth, under those scientific methods that would be required under this. The reason I bring this to the attention of the Congress tonight, and in context of the debate of violence in the classrooms of America, which in part can be because of a lack of discipline or control that somehow our courts and this Congress has wrestled away from local school boards and state officials in being able to control deviant students as they would attempt to establish an educational environment. Now, we're going to debate the crime bill in a few days. Hopefully, we'll see a conference before us. And in that context, I hope that we can make sense of bringing about some good criminal law for this country. We passed a Brady bill recently. We said that was it, or at least some of the gun control advocates said that was it. The report says no measure is the answer. The Brady bill is a small step. And then it said, and this is the report, we want this and more. in an absolute form of attempting to establish a new mindset for control. It says a focus on children. Believe it or not, they want to use children to educate children, if you will, to manipulate the mind. And I don't often come to the floor and talk about these kinds of things, but this report by this administration has it in print, and when they found out that what their people had said was controversial, they tried to hide it. So let me say in conclusion, Mr. President, after I wrestled this report out of the hands of this task force, I now have it available in my office. I think it's interesting reading for senators and other people who are interested in public policy, but most importantly, interested in trying to bring about good law that controls criminals, that creates the kind of environment that the senator from Washington is trying to create, that allows discipline in our society, instead of somehow using the argument that we are out of control and in that environment needing to take away certain rights from individuals that are now current and constitutional. Those are important debates. What the senator from Washington does is constitutional.
Time has expired.
What the senator from California did was constitutional. But let me suggest that the report of this administration skirts on the edge of ignoring our rights and our Constitution.
Mr. President.
Under the previous order, the clerk will report the Jeffords Amendment.
The senator from Vermont, Mr. Jeffords, proposed an amendment number 2425. At the end of Title IV...
President, I ask Nancy that the reading of the amendment be dispensed with.
Without objection, so ordered.
Mr. President, I ask for the
Wheels
ayes
time.
and nays on my amendment.
Is there a sufficient second? There is a sufficient second.
Now, Mr.
Senator from
President,
Massachusetts, Mr. Kennedy.
as I understand it now, we have, there's a time allocation, 45
The senator
minutes.
is correct. The senator from Vermont has 30 minutes. The senator from Washington has 45 minutes on the
other way around.
amendments. Excuse me.
President,
The
I
senator
believe-
from Vermont has 45 minutes. The senator from Washington has 30 minutes.
So, as I understand it, there'll be a debate on both of those amendments.
The senator is
At
correct.
the conclusion of the time, there'll be back-to-back votes. The first vote on the senator from Washington and the second vote on the senator from Vermont.
The senator is correct. Wheels time.
Mr. President.
Senator from Iowa, Mr.
Mr. President, I would yield 10 minutes to the gentleman from Iowa.
Senator from Iowa,
Yield more as time goes by.
I appreciate
Mr.
it.
Harkin is recognized for 10 minutes.
Well, Mr. President, the speech that the senator from Idaho just gave was an important speech, but it was sort of off point of the amendment that we have before us, or the two amendments we have before us. Mr. President, let me see if I can, for the benefit of the senators who are here and who may be in their offices, try to lay out the scenario of what we have here. We have two amendments pending, a Gorton amendment, a Jeffords amendment, first vote on Gorton, and then a second vote on Jeffords. Now, what are the differences here? First of all, Mr. President, if I did not know the senator from Washington better, and I know him well, and he's a good man, I would say that this amendment is a mean-spirited amendment. But I know the senator better than that, and I know that he is genuinely concerned about violence in schools, as I am, and as we all are. I also know that the senator from Washington would not in any way want to take away rights held by the most vulnerable in our society, Mr. President, the most vulnerable in our society, kids with disabilities. No, I don't think the senator from Washington would want to tell our most vulnerable members of our society, kids with disabilities, I'm sorry, you have no due process rights. What is the issue here, Mr. President? The issue is whether or not the careful balance that has been struck in the Individuals with Disabilities Education Act, which was built upon the Education for the Handicapped Act that goes back into the 1970s, whether or not that careful balance of providing due process rights to children with disabilities and their parents and the interests of the schools, whether that careful balance will be ripped apart. That is the essence, basically, of at least one part of the amendment offered by the senator from Washington. Now, really, the senator from Washington has two parts to his amendment. The first part, dealing with a weapon at school by a child with a disability. When we passed the Guns Free School Act, the amendment offered by Senator Dorgan, Senator Feinstein, was added as a part of the bill. It covers basically children who bring weapons to schools, but it leaves out children with disabilities. The senator from Washington brings children with disabilities under that Gun-Free Schools Act and says that no matter what, disabled or not, if you bring a weapon to school, then you can be expelled from school and kept out of the school for 90 days. To that extent, I have no problem with the amendment. Weapons are well defined. You know if a kid has a gun or something that can injure anybody else. We've heard all the stories about screwdrivers and things like that. To that extent, we support it, and that's what the Jeffords Amendment does. The Jeffords Amendment encompasses children with disabilities under the Gun-Free Schools Act. So what's the difference between Jeffords and Gorton? It's the second part of Gorton that I believe is so harmful to kids with disabilities. Here's what it says. He said that in his amendment, he talks about a weapon, then he says, or a child with a disability who has demonstrated life-threatening behavior in the classroom or on school premises. That kid is treated just the same as a kid with a gun. That's what rips apart the Individuals with Disabilities Education Act and the due process rights of our kids and their parents. Because what happens then is if this child demonstrates life-threatening behavior, then they can be kicked out of school for up to 90 days. And then if the parent of the child decides to contest that in a due process hearing and decides to go to court, why then, Mr. President, the child will be kept out of that school until the whole process is finished. That could be a year. We know how long it takes sometimes for court cases to be held. So a child could have this life-threatening behavior. Well, the senator then tries to define life-threatening behavior. Now, Mr. President, this is what galls me more than anything else. The senator defines life-threatening behavior as, quote, an injury involving a substantial risk of death, loss or substantial impairment of the function of a bodily member, organ, or mental faculty that is likely to be permanent, or an obvious disfigurement that is likely to be permanent. Now, where did this definition come from? This came from the sentencing guidelines for convicted criminals. We're not talking about convicted criminals here, my friends. We're talking about the most vulnerable members of our society, kids with disabilities. And we're going to say, okay, we're going to say life-threatening behavior, same for you as for a convicted criminal about to be sentenced to prison. Life-threatening function that says here, a substantial impairment of the function of a bodily member. What about a kid that has epilepsy and has an epileptic fit and falls over and hits his head? That's life-threatening. Or mental faculty that is likely to be permanent. What about an autistic kid that sometimes beats their head against a wall? That could be life-threatening, or it could be threatening to permanently damage that kid's mental faculty. Has nothing to do with whether that kid's a criminal or not. It has something to do with whether that kid is disabled or not. So we're not talking about convicted criminals. We're talking about the most vulnerable members of our society. Then the senator sunsets it. He says, well, we'll sunset this provision until we reauthorize the Individuals with Disabilities Education Act. Mr. President, we have settled law in this area. We have a Supreme Court case, which I'll talk about momentarily. It's working well. What the senator from Washington would do with this amendment is stir the pot until we're able to report out a reauthorization of the Individuals with Disabilities Education Act, which my subcommittee on disability policy will report out sometime next year. But what this would do would be open the doors for school districts to be able to define life-threatening behavior, throw kids out of school because they're disabled. Now, you might say, well, schools wouldn't do that, would they? Mr. President, that's exactly why we passed the Education of the Handicapped Act, why we superseded that with the Individuals with Disabilities Education Act. History is replete of kids with disabilities being shunted aside and thrown out of our schools and not educated simply because they acted a little bit different or because they had a disability. And again, Mr. President, I have in Iowa, we have Mike McTaggart, principal at West Middle School in Sioux City. He put it this way, he said, I have no problems with the education guidelines. Before, Mr. President, and I asked the senator from Washington to listen to this, before Mr. McTaggart became principal at the school in Sioux City, their school had 692 suspensions. 220 of those were disabled. But Mr. McTaggart took over the school. He instituted policies of guidelines for the teachers, reaching out to the parents to bring the parents in to talk with them, setting up individual education programs for the students. And what happened after he took over the next year? They had 122 suspensions, 0 were disabled kids. From 220 in 1 year to 0 the next year. And that's because we had a superintendent, who understood what it meant to have these guidelines in practice for disabled kids. This is what the amendment offered by the senator from Washington would rip apart. Again, I repeat, the Jeffords Amendment, and to the extent that the senator from Washington wants to reach to those kids who bring weapons and guns to schools, I have no objection to that. He's right on target. But to the extent that the senator from Washington wants to say that any child with a disability who exhibits a life-threatening activity as defined in the sentencing guidelines for convicted criminals, and then they can be thrown out of school. Mr. President, that's blatantly wrong. It is wrong. And we can't allow that to happen. Everyone cares, Mr. President, about making our schools safe. No one cares more about having safe schools than parents with disabled children. Because it's their kids that are usually the most vulnerable, the most picked on, the ones most threatened in our schools. Parents with kids who are disabled care very much
The senator's time has
about
expired.
safe schools. 5 more minutes.
Senator has 5 additional minutes.
And we're all concerned about the school officials to ensure that they have a safe environment conducive for learning, especially for kids with disabilities. Mr. President, the amendment offered by the senator from Washington is opposed by many key education groups. The National PTA, the National Education Association, the National Association of States Boards of Education, the Council of Chief State School Officers opposes this amendment. The National Association of State Directors of Special Education, the Council for Exceptional Children, the Councils of Administrators of Special Education, the Consortiums of Citizens with Disabilities, and the National Parent Network all oppose the Gorton Amendment to the extent that he reaches disabled kids, not just those who take weapons to school. This amendment, as I said, tears apart the fabric of IDEA. Mr. President, earlier in the day I said to the senator from Washington and others that I have chaired the Disability Policy Subcommittee with great pride since 1987. Not once have I brought a bill dealing with disability issues to the floor of the Senate to have it amended. I don't do that because I believe disability issues are so important that they shouldn't be subjected to partisan wrangling or to inflammatory speeches, anecdotal types of stories that may inflame passions. Since 1987, and I say this with great pride, we have worked together with members from the opposite side of the aisle, Senator Durenberger, who's been my ranking member since then. We've brought in disability groups, we brought in schools, we worked these things out before, so we have a consensus agreement and we have support. So that when we bring a bill out here on disability issues, as I said, we've never had an amendment. I don't intend to have one on IDEA either, because we're going to work it out. And we're going to cover these issues. But let's do that next year when we reauthorize IDEA, the Individuals with Disabilities Education Act. Let's not do it on this bill. And so we should reach a consensus. Lastly, Mr. President, the Gorton Amendment ignores Supreme Court ruling, 7-2 ruling. 1988, very conservative Supreme Court. And the only two dissenting justices objected on mootness grounds, not on the essence of the case. The case is Honig v. Doe. Right on point with the issue I'm talking about. It had to do with a school district that threw some kids out because they were acting up, because they were disabled. And I have to say this because if you listen to the senator from Washington, you'd think that these schools and the teachers and superintendents have nothing available to them if kids act up and act in a threatening manner. Let me read what the Supreme Court said in that 7-2 decision. Our conclusion that 1415E3, this is basically the IDEA bill, means what it says does not leave educators hamstrung. The Department of Education has observed that while the child's placement may not be changed, this does not preclude the agency from using its normal procedures for dealing with children who are endangering themselves or others. Such procedures may include the use of study carrels, timeouts, detention, or the restriction of privileges. More drastically, where a student poses an immediate threat to the safety of others, officials may temporarily suspend him or her for up to 10 school days. So already, if a child with a disability acts up, the school can suspend them for up to 10 days, during which time the parents and others, as is said, this authority, which respondent in no way disputes, not only ensures that school administrators can protect the safety of others by promptly removing the most dangerous of students, it also provides a cooling down period during which officials can initiate IEP review. That's the Individual Education Program Review.
Additional 5 minutes has expired.
I need just 2 more minutes.
Senator from Vermont.
Just 2 more minutes.
I yield the gentleman 2 additional minutes.
A cooling down period, and seek to persuade the child's parents to agree to an interim placement. And in those cases in which the parents of a true